Hi, this is Hannah, and you're listening to the University of Chicago Public Policy Podcasts. You're listening to Root of Conflict, a podcast about violent conflict around the world and the people, societies, and policy issues it affects. In this series, you'll hear from experts and practitioners who conduct research, implement programs, and use data analysis to address some of the most pressing challenges facing our world. Root of Conflict is produced by UC3P in collaboration with the Pearson Institute for the Study and Resolution of Global Conflict, a research institute housed within the Harris School of Public Policy at the University of Chicago. What are the key legal principles that govern the conduct of war and protect human rights? In this episode, we speak with Professor Kathleen Cavanaugh, the Executive Director of the Pozen Family Center for Human Rights and Senior Instructional Professor in the college at UChicago. Professor Cavanaugh's scholarship, like her academic training, is interdisciplinary and seeks to interrogate questions of law in its social context. She has published on international human rights and humanitarian law, theoretical as well as applied research on the use of political violence, ethno-nationalism, and more recently, militant democracy and the politics of memory. As a consultant, she has undertaken numerous missions on behalf of Amnesty International, including to Northern Ireland, Israel and Palestine, and Iraq. She will be speaking at the 2024 Pearson Global Forum in October. In this interview, we discuss, among other topics, the framework of international humanitarian law, storytelling in meta-conflicts, and the difficulties of accountability for human rights violations within the international system. Now let's go to my conversation with Professor Cavanaugh. Hi, my name is Hannah Blickji. I'm a second-year MPP student here at the Harris School of Public Policy and the producer of Root of Conflict and a Pearson Fellow. And I'd like to thank Professor Cavanaugh for coming into the studio today for an interview. Professor Cavanaugh, could you please introduce yourself and your work, and welcome to Root of Conflict.
Percy, thank you for having me. I'm Kathleen Cavanaugh. I'm director of the Pozen Center for Human Rights and faculty in the college. I'm a socio-legal scholar and have come to Chicago just about 4 years ago today.
Welcome.
Thank you.
How did you first get interested in your work and studying conflict as it is over time?
Sure. Well, I've specifically said I'm a socio-legal scholar, and one of the seminal turning points for me was my time in Northern Ireland. So I went to study as an undergraduate student on a junior year abroad in Belfast, Northern Ireland, where I was looking at the underpinnings of protracted social conflict. And there are a couple of things that sprung from that really helped to shape and form my concentration on what I call the politics of law. And three things in general, I think, not just sprung from the conflict itself, but also shaped how I approach the study of human rights and also humanitarian law. The three are meta-conflicts, storytelling, and lawfare. And so I'll circle back to those in telling a little bit about Northern Ireland, because your audience may or may not be familiar with the conflict, but it was a protracted social conflict. And the interesting part when I landed in Belfast was that there were so many different versions of the underpinnings of the history that led both Unionists, British, and nationalists who sided on the Irish side to have this protracted social conflict. And amongst them was whether or not there was a settler colonial society, which was part of the Irish nationalist argument, or whether or not this was an ancien regime, right? Was this a natural flow of peoples from Great Britain, mainly in Scotland, over to the north, and therefore these were peoples who had legitimate right to be there, right? And depending on where you started in that history telling that story, also informed how you saw any resistance to colonial rule. So if you were an Irish nationalist, that you saw the British government, you saw the laws and the infrastructure of the British government there as a colonizing force that needed to be removed. And if you were a Republican, you felt you could do this through the use of violence. If you were a Unionist, you felt this was a lawful government, and that if you wanted to change the structure, the nature of the government, you needed to do it through constitutional means, right? And absolutely everything that flowed from the use of human rights and the language of human rights to how you actually saw your ability to get a job or to live in a particular area flowed from those lenses. And that's when I talk about a meta-conflict, because a meta-conflict is not just a conflict, an actual conflict that's happening on the ground, but it's a conflict about the nature of a conflict. And that rolls into the storytelling, which is that in order for me to be able to speak and talk about what was happening in what they colloquially view as the Troubles or call the Troubles, I needed to be able to understand those perspectives. And it wasn't about truth-telling. It was about storytelling, because those that were involved in the conflict had a particular perspective that was born of how they've seen the past. And that kind of contemporary past influenced how they spoke with me, influenced whether they saw the state as representing them or not, adversarial or not. And then the last thing that kind of got fed into this is the use of human rights. Because if you were a unionist who believed that the British were lawfully there and it should be considered a lawful government, then the use of human rights was something your adversary did. Because Republicans and nationalists could draw on human rights because most of the violations against the nationalist population were coming from the state, right? Unionists saw this and thought, well, human rights really is just a tool for nationalists. It doesn't really represent us. Why? Because the violence that they were experiencing were coming from paramilitant groups. And here's the rub. International law is about states. States sign up to it. States are meant to implement it, and states are held accountable. Non-state actors, it's very difficult for human rights groups like Amnesty or Human Rights Watch to talk about this because it's not these non-governmental groups that actually engage in this treaty making, right? So human rights became part of this. Human rights, as well as law, became the surface over which these political struggles were waged. And all three of those things, meta-conflict, storytelling, and lawfare, and the reason I call it lawfare is that the original concept of lawfare is that you take things off the battlefield, off the streets, and you bring them into the courts. But what we started to see happening very quickly is that sites of power, states, or even non-state actors use the constructive ambiguity of law to actually try to shape and form how we understand what that means, right? So human rights became part of that conflict, part of that contestation. And we don't just see it in Northern Ireland, of course, we see it all over, right, where states try to tell us and have the hegemonic control over how we understand what these things mean. And I saw like the very roots of it in my time in Northern Ireland as an undergraduate. And it just continued to inform how I look at conflicts, how I approach conflicts, but also how I see law as part sometimes of the conflict, not as the neutral arbiter.
In terms of the non-state actors and state components of that, could you briefly explain the framework of the either not just international humanitarian law, but how international law sets human rights in a way? That might not be the right way of framing it, but the overview, just in case people aren't aware.
Sure. So I'll do this very quickly. The main umbrella, if I can put this, for international law is public international law. And there are a lot of parts that you pull down that address very specific topics. For our purpose today, I'm going to concentrate on three: international human rights law, international humanitarian law, and international criminal law. And they govern specific things. We say in law, lexis specialis. What is the specialized form of law? And the specialized form of law always is about the law that is the most relevant at the time. So human rights law, the international treaty system that makes up human rights law, is applicable during times of peace. So international human rights law is applicable now. States sign up to it and must, when they sign and ratify it, abide by its principles. En principe, right? In principle. International humanitarian law, also known as the laws of war, govern what happens when a state goes to war, when a state goes and reaches the level of armed conflict. It becomes the specialized law, the lexis specialis. It doesn't mean human rights law is silent, but it means this is the law that we hold states accountable for when you're in conflict, right? And it's important because if you think about it, you as a combatant in a armed conflict situation can kill somebody, right? If they're your adversary. in a situation that is much less the threshold than if it was in a time of peace. So if you're a police officer, you can take someone's life in a time of peace, but you must do everything before to protect that, right? You try to take them in custody. You try to do everything to mitigate that last resort. If you're in a time of conflict, a right of life lowers, right? Because you're adversarial. That's why the lexus specialis is important. So humanitarian law, or the laws of war, govern what happens during war. Criminal law governs what happens when there are violations in this middle section. Violations of war crimes, crimes against humanity, or genocide. So once you have these violations, and inevitably war is going to have them, what do you do with them? What do you do for the victims, civilians that may have been mistreated, even prisoners of war that may have been tortured? You need a place to bring that. And so you have this last body called international criminal law, which is ostensibly the accountability part of it, right? Non-governmental actors, which is what you've asked about. In human rights law, it's very difficult to find a place because, again, states sign up to it. So we've very often reached a kind of a common article in the Geneva Conventions. Not to get too specific, but there is a commonality that says you can't torture someone. So these are the kind of basic principles that everyone, regardless, should be held accountable for. It becomes much harder when you have paramilitant groups operating outside of a conflict situation to hold them accountable. Full circle to why it was difficult to talk to some communities in Northern Ireland, because if you're Amnesty, they're asking you, why aren't you holding the IRA accountable? The mechanism simply did not exist for that. Humanitarian law, however, has started to develop more and more because if you think about it, most conflicts are non-international armed conflicts. That is, it's a conflict between a state and groups within a state, right? So these groups are not part of a state military. These are non-state actors who, for whatever reason, and across the globe, there's a variety of different reasons why people levy en masse, right, why they take arms. They don't have the same structure. So what do? Does humanitarian law just become silent? And so you have a lot of people, particularly within the International Red Cross, which is kind of the curator for humanitarian law, trying to develop ways to engage non-governmental actors to abide by the laws of war. And so you are seeing a development of protocols, you're seeing a development of standards, and you're even seeing training of these extra groups under the laws of war so that you still are able to hold them accountable. It's not always successful. You have to have them willing to participate, but at least to have them familiar with what the laws of war are, because if you think about it, if the state captures their combatants, their armed actors, then you want them to be treated the same way as they would if they were actual state-to-state combatants. So that is the second group. The third group, which is international criminal law, again, you're kind of trapped within this idea that you must hold state actors accountable and those that are fighting. But that does not preclude also being able to hold non-governmental actors accountable in that third realm.
Going off of that, I think the three things you said were meta-conflict, storytelling, lawfare, on how that relates to this framework of law. Could you go into a bit more of that?
So it can help maybe on the lawfare part of it. Mm-hmm. One of the things, without going too much into the weeds of international law, one of the things to note is that a lot of the treaties that will be signed up to by states, right, whether it's human rights, particularly human rights treaties, but also humanitarian law, have a certain degree of constructive ambiguity, a certain degree of what I call wiggle room, right, interpretation that can happen. And with that wiggle room, the states and even non-state actors will try to take advantage to their benefit. So if we think about, if I move it to this question of torture, this is actually a really good topic for kind of illuminating why constructive ambiguity can actually move, and also this principle of evolutiveness. So you'll have states that will argue that these conventions and treaties were set up a long time ago, right? Many of them were codified in the 50s, 60s, ratified in the 70s. Times have changed, right? So those who choose to use violence, those who choose to act outside of constitutional norms, are now much more prepared to use these very lethal weapons that weren't existing in the past. And so we need to be able to be responsive. And so you've heard this idea, the ticking bomb, right? Mm-hmm. So if you have somebody in custody and you know they have information and you know by extracting it quickly, you'll be able to save countless lives. That's the ticking bomb scenario. That invites us into this world where you allow the state to lower the threshold on what is considered an appropriate interrogation method that may actually be close to torture. So that bit that the state is able to take from a prohibition against torture, which is one of the strongest human rights prohibitions, that can be manipulated to tell you that we have to do this because we're protecting you, right? So the lawfare part of it is that they take a legal prohibition that they know is a prohibition at all times in all cases, and they try to change the narrative around it. The narrative for why it was maybe at some point a good prohibition, but now we need to change it a little bit, because no longer is it about a prohibition against you. It's a prohibition that is being applied to somebody who threatens you. So you take the human out of the person, you call them a terrorist, and then anything goes, right? And so this is where the contestation is happening, both because the language of law allows it. It's ambiguous. If you're going to get a lot of states to sign up, something has to have a little bit of wiggle room, right? You want to get them to sign the dotted line on these human rights treaties, but it means you need to leave a little finesse. That finesse is meant to be filled in by judges, by jurists, opinionierists, but sometimes it's done by states. And when states take control of it, it may actually erode its very value. And that is what we're seeing. We've seen it in human rights law. Torture is a case in point, but we've also seen it in humanitarian law, which goes back to this issue that we confront today, is how do we understand the principles that are involved in the laws of war, and how do we apply them so that we understand when states are arguing that this is justified, what they're doing, is it justified? And there are lots of parts of the Geneva Conventions, which are the laws of war, Geneva 1 through 4 and its additional protocols, that have been reframed by states who are asking us to understand what their restrictions are differently.
How flexible do you think that's the system is in terms of, like, as you're saying, right, judges are supposed to be filling in, but states are doing this more so now. Do you find that there's more of a degradation of rights instead of this filling in the gap of the wiggle room that you mentioned? How is it supposed to be working? And if it doesn't seem to be working that way, what are the mechanisms that are lacking?
So there are some legitimate concerns around human rights, but they're not necessarily the concerns states raise. So I'm going to stick with human rights and then I'll go to humanitarian law. There are legitimate concerns and critiques of human rights, very often known as the tainted origins, by anti-colonial scholars. I'm one of them, right? But it is not to take away the power of human rights. It's actually to make sure that that power is equally vested no matter where you are from, right? So this kind of north-south divide where the north controls how we understand rights and the south simply needs to be subservient to it needs to change. And so there are a lot of scholars, myself and others, that are part of movements that are asking to narrate and fill in those blanks, but to give it strength, not to weaken it. Judges and jurists can either do that, and sometimes they're part of their political landscape, right? So you'll find judgments by judges that you might find problematic in the human rights context, and we've seen that also globally. States have a different stake in this game. There's a wonderful quote that says, international law is not a suicide club for states, right? So states don't like to be restricted by supranational powers. They, at all costs, want to protect their borders. And so their critiques on human rights very often is that it's northern controlled, it's Western, it's liberal, all of those things. But it's not because they actually want to make it more universal. They're not anti-colonial scholars trying to fill in the blanks, but they're trying to remove themselves from scrutiny. So there's a push and a pull. And it's a continual contestation between those who actually want to strengthen the human rights regime and those that want to weaken it, and those that want to change it for strengthening reasons and those that want to change it for weakening reasons. So there are advancements that have been made, but I think when you have states like the United States or France or United Kingdom that are participating in this weakening, it becomes problematic because states only are going to hold their part of the human rights the human rights framework in accordance with other states. That's how you get human rights to work. You leverage state to state. But if you have most states now trying to undermine it, there isn't very much leverage, right? You can have India look at the United States and go, well, you guys do it in Guantanamo Bay. What's the problem with us doing it, right? Mm-hmm. And that's where the battle lies now. And those that are trying to inform this space keep trying to push back on that trend.
Right. That kind of goes into one of the questions that I was going to ask about how states use human rights as a political, in their arsenal in a way, that it becomes a discourse between countries where you can use human rights violations in one country as a way to demand change, but then the finger could be pointed back at that country and they have their own host of human rights violations. Could they be considered absolute, or are they relative? I mean, I guess in reality, they're relative to cultural construction, right? How does that influence the legitimacy of enforcing them internationally across cultures, religions, and identities? And if we're looking at this from this international space.
Yeah, it's a great question. So there are parts of human rights law that are non-derogable, and there are parts of human rights law that are absolute, and there are parts that are limited and restricted. The absolute rights are things like the right to life, save for certain circumstances, torture, slavery, and you cannot be convicted of a crime if it wasn't a crime at the time you committed it. Those things are non-movable. Mm-hmm. And at all times and all places, regardless of where you're from or what your religious belief is, those have to be upheld. Increasingly, human rights instruments are seeing your right to hold a religion and to practice a religion to be part of that. But then there's a whole slew of rights, what I would call the majority of rights, that are limited and restricted that already have that cultural relativism built into it. And this goes back to why I said sometimes you need that to get states to sign up to it, right? Because you have different systems of law, civil and common law systems. You have different religious beliefs. You have different ways that you look at expression. You have different ways that you look at equality. And so in this kind of human rights framework, there are lots of ways for states to be able to maintain their individuality, their cultural autonomy. And then there are other things that it simply doesn't matter where you're from. This has to hold. That's why the cultural relativist versus universalist debates doesn't really make that much sense to me because a lot of it's already embedded, right? I think there are other parts where that struggle becomes much more evident, but that's where you actually have the narration of what it means. So the Convention Against the Elimination of All Forms of Discrimination Against Women has the most reservations based on the fact that a lot of states that have signed up to it try to make their own interpretation of what equality means. Because for some places, equality does not mean equality between a man and a woman. They read it as equality between men and women, right? And that's where you see that kind of push and pull happen on cultural relativity.
How have recent conflicts like those in Palestine and Ukraine challenged existing legal frameworks for human rights protection?
So they've challenged in a couple of different ways, and I'm going to pull it back not just to talk about the legal frameworks, but also the way we see and understand armed conflict and the ways in which humanitarian law is applied or not. So I think in the public realm, Ukraine, when it first happened, when Russia, quote unquote, first invaded Ukraine, there was a lot of public support and sympathy for Ukrainians, right? And there was a call by the international community for Russia to restrain, for it to protect civilians, for it to have humanitarian corridors. We heard the language of the Geneva Convention amplified by the international community. With Gaza, it's been much more contested, right? And for there, I would say it's because in our public realm, there's a contestation that has not stopped, much like Northern Ireland, but in a very different way, right? About claims to territory and about the rightfulness of action. And I think the politics of law in that case weighs so heavily. So anytime you want to talk about Israel and Palestine, even how you refer to it is a signal. So calling it Palestine, right, and calling it Israel instead of Judea and Samaria, calling the occupied territories. All of this is that kind of messiness. And this is where lawfare is like up front and center. Because the arguments that have been waged, and I do mean waged, within the kind of public square, but also the arguments that have been waged among international legal scholars, is all around whether or not the actions that are being taken right now in Gaza are somehow justified, right? The issue for me is a lot of the justification comes from whether or not Israel had the right of self-defense. That is one part of humanitarian law, which is jus in bello, right? Do you have the right of going to war? Once you, however, have engaged in conflict, the laws of war, Geneva 1 through 3, are what applies. It doesn't matter whether October 7th gave you justification or not. That goes silent. And then there are a list of prescriptions that you should follow. And first and foremost is that you try to distinguish between military and civilian. So when you listen to the arguments of why hospitals are being bombed and why schools are being bombed, you will always hear because there was a Hamas person there. And that, of course, can be said for any infrastructure inside Gaza. But what is failed to kind of be pulled through is this principle of proportionality, which is that even if you only have a few fighters, you can't bomb a hospital where you know there are hundreds of people being treated and it may be the only hospital. My point in engaging this isn't the rightness or wrongness of what's happening in Gaza, but the ways in which humanitarian law itself has become part of this conflict, and it's actually become a victim, I would argue, to this conflict. And it precedes Gaza. Israel and the occupied territories have been one of the conflicts that really has shaped humanitarian law, particularly the laws of occupation, which is Geneva 4. Why? Because you've had over 50 years of occupation. And the Geneva 4 isn't prepared to handle 50 years of occupation. It's meant to assume that if you're on the territory of another party, you leave within the year, right? And it's geared for that. But if you're around for 50 some odd years, what you start to hear is that this isn't fit for purpose. Think about what I said about human rights law before. Torture was back then. Now it's a different story. This was codified in the 1940s. Wasn't expecting. It's a sui generis situation. You'll hear that term. And so therefore, we have to think about this differently, right? All the while, they're thinking about it differently, but not to, in some way, strengthen, but to weaken. And that is what you have now going on in Gaza. And so it's a political debate. It's not a legal one.
Right. I think this sort of goes into this question I have of how does social media and the prevalence of mass communications change the perspective of what is just versus what is lawful, right? Seeing what we can see now every day, I think there's this sense of what something may be versus what it isn't in a just sense versus what it may be. It may be different when you look at it from those legal frameworks you've been talking about.
Firstly, I think social media has contributed enormously for understanding what is happening on the ground, because there is a lot of contestation of whether or not media has been controlled, right? And whether what we're seeing is filtered. And it is true that when you're looking at TikTok or you're looking at an Insta posting, or you're seeing video that's been uploaded, you have to wonder about authenticity. But it does at least fill in the blanks, because otherwise the media that's there can be controlled of what can come out of a conflict. And I'm not just talking about Gaza. So social media in some ways opened up that space, and it's given us a lot more avenues to access truth-telling. I think the question of what is just versus what is law is a really interesting one, because I think for me, law and the rules and the principles that all players are meant to follow, when and if they're followed, lead to justice. But very often this doesn't happen, and you don't have any justice. And very often you can go through and you may have a very unjust outcome, and justice isn't achieved. So justice, for me, is something you work towards, and it's not just through the laws, but it's also through civil society participation, for us to be curious about what's happening, to raise our voices, to look for that justice that may not be available through the mechanisms that are available to the people that are seeking it.
One thing that I wanted to kind of circle back on, which we were talking about in the sense of how I think the changing of war in a way, even just this idea of the context of stuff that comes through and how we're seeing media, this prevalence of AI that we've seen, things being doctored, whatnot. What are the ethical implications of, thinking of drone warfare or AI-related warfare, that sort of this targeting warfare? I mean, it's in Israel, Palestine, but also I think like more broadly, as war changes, how do modern technologies contribute to that wiggle room that we have in terms of human rights, but also the legal frameworks? I don't know if that's the...
It is, and it's a great question. So there are people that concentrate their entire, I shouldn't say entire, good part of their writing that are legal academics that deal with AI and war. So if you have a drone, and you're right, it's not just been you. The Americans did it in Pakistan, right? So how do you hold what is essential in artificial intelligence accountable? Well, you can, because they're not acting outside of the control of an armed force or a state actor, right? And so humanitarian law in those situations can apply, so does human rights law. So it's not outside, but this is, again, the arguments that I had originally talked to you about at the beginning about the evolutiveness of human rights. I had said that there are two things that really help to frame our understanding of human rights, and the reason why there's this push and pull. The first is constructive ambiguity, which is enough wiggle room so states will agree to sign, and then it's up to opinion bureaus, judges, jurists, court decisions to fill in the blanks. But the second is evolutiveness. So international law understands that when it's codified, it's going to change over time. And so jurisprudentially, so too can enforcing mechanisms. It can look at things differently. It can say what we thought was okay then isn't okay now, or we need to add something more to it. So treaties very often have additional protocols to deal with these additional problems that arise from technology. And international law is always trying to keep up with these advancements. So I don't think that there are any big gaps. I think there are ways in which you have those that are looking to fill the gaps continue to work, and those that are looking to lessen the control continue to try to do so.
In looking at this concept, right, and just in general, and what gives you hope for the ongoing struggle to protect, right, human rights and humanity in the face of armed conflict? Like, is there a specific thing that that's like a through line, or I don't know if there's like, I know sometimes it feels like if things are changing all the time, is there something that you see as not that everything is negative, but as something as like a positive force moving forward?
I think so. I mean, this goes back to this idea of how you speak law to war. There is a wonderful article that was written just at the beginning of 2003 by Joan Fitzpatrick, and I will get to your question in a minute. And she wrote this article called Speaking Law to Power. And there she was focusing on human rights. I think for all of us who are invested in this notion that law can be both a positive and negative, a political player and not, believe that there's something to the wish by the international community in general, civilians as well as states, to be part of a system that moves towards states of peace, right? It may not be the case for all actors, but I think for the most part, a choice between being in war and being in peace, most people would choose peace. But there has to be structures in place that help us get there and show that there's an accountability that has a rule of law quality to it, to which everybody is held accountable. And I think that the international human rights system, as well as humanitarian law, was set up to move towards this kind of utopia. We may never get there, but we keep moving towards it. And I've seen enough change and enough victims and interviewed enough victims in my life to know that they believe this to be their refuge, right? And certainly human rights law, both those that are enforced by courts and in other enforcing mechanisms, have made changes. And we have seen that, right? So if we look at the death penalty, we have seen more and more states be prohibitionist states for the death penalty. That was a big push that happened under the umbrella of human rights law. So there are victories to be able to share with you, but there's also challenges. But I do believe in the promise of it. And I think that that's what we keep reaching towards. And I also think the international community more and more is willing, at least, to, and by international community, I'm not talking about states, to stand up to recognize that there are certain things that are happening globally in this current political landscape that has to be addressed. I think the encampments on campuses is a way of showing that, right? It's an awakening, and whether or not it's fully understood what's happening amongst the students, it is a moment which I feel a great deal of hope that the students of this generation believe in something that is better than where we're at the moment, and also want to challenge authority that seem to not want to challenge those structures that bring about inequality and injustice. And that gives me a great deal of hope.
That's great. Thank you. I guess I keep saying I want to circle back on different things, but one of the things that I wanted to just elaborate a bit on was this idea of storytelling. Mm-hmm. I think you talked about interviewing people who have experienced conflict. The value of a story, I think, gets across much more than what we see just through numbers. And I was wondering if you have an example either of a story, or what I'm really thinking of is we think of many times where stories are used for negative outcomes, right? You think of like this, like, I guess I'm thinking of a specific time where you can use negative stories to say, like, we need to have something to combat bad things. But do you also have examples of good stories that can help?
So I think I probably have to redefine storytelling, because it's something different, I think, than what you're thinking of, at least in an academic term. I understand what you mean by talking about individual victimization or individual stories of hope, right? Storytelling for an academic is really the ways in which you will understand as an ethnographer that people will present a situation to you that is through their lens. And their lens may, for you, not be truth-telling, but it's how they're informed. Another way of looking at it is we sometimes call the Rashomon effect, the Kurosawa movie, where you have one incident and 5 different witnesses, and you see it through each of their lens. Their lens is informed by their history. So they see something very different than the person next to them. That is storytelling, and that's where you pick it up. The point I think I can draw back from you is in interviewing people, as I've done, like I have 2 hats, right? I'm an academic, but I've worked a lot with Amnesty International on missions. And there you interview victim after victim after victim. And for the most part, the stories they tell you and the stories that you then, as a human rights advocate, wish to share for the world will be those stories that are going to be very depressing. Why? Because it's going to get civil society to move much more than the stats will, right? Much more than an academic article. But what I have seen come from this is the hope, and this goes back a little bit to what I just said before, they have a hope that the human rights framework will assist them in this, because they feel where they're being violated, very often by the state, there is no justice. There is no recourse. And so they have a great deal of hope that once that's lifted up outside, there will be something there that will hear their victimization and something that will be there to redress it. And that's the hope. It's a hope through very difficult times for them, but they do have that hope, and they continue to, even though they're knocked back time and time and time again. And so for me, the reason, even with all of my critiques of the human rights frameworks, that I stay in it is because they do. And they really do believe in something better.
This year's Pearson Global Forum is on negotiations and agreement, which you are presenting at in October. How do you see this concept that we've been speaking to fitting into the theme of negotiations and agreement?
It's the precursor, I suppose, to that. I think the first thing that I would say is that all of what I've spoken about today about humanitarian law, about human rights law, has led and is informed by contestation. And there is a politicization of law that happens. And I think that when you get to the negotiation table, there are going to be leveraging of accountability questions, right? So you'll have states that will argue that there has been violations on the part of the other. You'll have states that will argue that they have actually upheld their commitment to either human rights or humanitarian law. And I think the acceptance is that they're going to come with very different perspectives, because the stories that they're telling about why they went to war or why they abused particular rights are going to be very different across the table. And I think for negotiations, there's an acceptance that there may not be a point of departure that they accept together, as long as at the end there's going to be systems of accountability that take both perspectives into account. And I think that those are where you actually have the most successful outcomes. The other thing that I would say is that we often think of negotiations and outcomes of negotiations as being forms of reconciliation, that in some way there's an acceptance, and some way there's a way of accepting the same truth and moving forward. In none of the conflicts that I have ever studied does that happen. Very often it is an agreement to have an absence of conflict and the presence of peace that's the motivating force, and to put a set of legal structures around which both parties to the conflict feel that they're protected. So in Northern Ireland, it was putting a consociational agreement around the final negotiations, which allowed for representation by both sets of actors, right? Both nationalists and unionists. In Israel and the occupied territories, when this conflict is over, there is going to have to be a move forward from Oslo, a move forward in negotiations. There's no way out of this, but there has to be a set of legal frameworks that allows both parties to feel that they're going to be protected as they move forward. So I think law has a role to play, but it's not necessarily in the understanding of the common acceptance of the underpinnings of the conflict, or who was the victims and who were the victimizers. It's making sure that when they leave that to get to their final negotiations, that they both sets, however many parties to the conflict, feel that they're protected.
I think that goes back to this idea of justice, that if people feel the sense of justice, then, or that there's a path to justice that can continue forward.
And this is where peace agreements, last thing I will say, this is where peace agreements are super important. So I know I've gone back to Northern Ireland a lot, but I am going to do it because it has held, it's one of those conflicts in which we haven't gone back to the conflict. And if you read the Belfast Agreement and the preamble, it is riddled with constructively ambiguous language. But basically, it says everyone has a right to these claims. If you boil it down, both unionists and nationalists are both peoples. They both have claims to territory. It is so ambiguous that everyone walked away feeling not only were they heard in their own historical trajectory, but they're going to be protected moving forward. Now, there's been bumps, but it was brilliantly done because no one accepted or was made to be the victimizer in this peace agreement. So peace agreements are really important in moving processes forward as long as they reach a final agreement that both parties can sign and feel comfortable with, and then work towards a complete end to conflict.
This idea of ambiguity kind of works in both ways, right? Where you have the wiggle room, but then it also allows for people to feel heard in both ways, I guess.
Yes, exactly. And in peace agreements, that's super important.
I think one question that we like to ask all of our guests is if there was one paper or book, a knowledge material that you think is important for any person studying public policy to read or to be familiarized with, what would you select?
There are a couple of, maybe I can frame it this way, because international law is so big and so many people have written about it. I will give a couple of authors that I think are really important to read, both anti-colonial scholars that talk about human rights in a way that allows us to reframe and capture, political philosophers, legal philosophers. So Paul Kahn wrote a piece I assigned to my students in Militant Democracy that's on torture. And it is one of the most brilliant pieces to have us understand how we can go from torture being seen as barbarian and prohibitive to how we are now accepting it. And by we, I mean we in this room, right? Not us personally, but civil society. So that would be one author that I would say in this particular piece to read. The other are scholars like Ratna Kapoor, who is at Queen Mary University, also University of Delhi, who's written about human rights and those frameworks that I had spoken about, the anti-colonial frameworks. But again, writing about it, not to tear it down without building it up in some very specific way. And those two, I guess I would leave, because the works on Northern Ireland and the works on Israel and the occupied territory are vast, and there's plenty out there. I would say just read both of the storytellings on those conflicts. But those were the two authors that I would highly recommend people will read.
Great, thank you. There's always a thing where I wish I had asked, I'll talk about something afterwards, or I think the thing that I'm trying to reckon with is, I guess, this idea of storytelling and truth in terms of different sides. And you were talked about the peace agreements and how people can come away not feeling like a victim. But is there ever a case or just in general where doing research, you have also written and are doing research on memory wars, which I think is something else that's a whole other category. But how people think about conflict and the ways that they perceive conflict, and even just what we talked about with Israel-Palestine, of saying if there's a Hamas person there or there's a Hamas member there, that's justifiable in terms of conflict. How do you either break apart the storytelling or get people to, in terms of looking at humanitarian, not just humanitarian rights, but human rights and seeing the humanity of people on both sides and that storytelling coming across the lanes to each side of the conflict? I don't know if I'm explaining myself super well.
You are, and I would say that I would pull it apart in this way. I do understand your question. So there's an idea of how you want to reach peace and how much you want to sacrifice justice to get there. I think you can reach a settlement that may be an unsettled peace or an uneasy peace and not have justice. Law requires that there is a sense of empirical fact that you can get to. And the storytelling then has to be moved away to say, if this person was killed, by what means were they killed? And if you're talking about a human rights situation, were all measures taken to make sure that that was the last resort, right? There are a set of facts that you can look at that will inform whether that was done or not. The storytelling is different. This is how we understand why state security may have killed paramilitants in Northern Ireland. And it may be a backdrop that they knew at some point they were going to do something, right? So they killed them in advance. That's the storytelling. But law says, regardless of who you think this person is, you needed to have arrested him or her. In conflict, we can look at whether or not it's difficult. I've been in war situations where distinction and proportionality are very hard to be able to measure. But you are able to look at things like, was there a corridor civilian corridor to allow people to escape, in which you had a ceasefire in place at this time. There are some empiricisms that can be looked at that are required for you to be able to determine whether or not these legal principles were upheld or they weren't, right? Whether or not there are perpetrators that are guilty or not that you hold accountable in this last branch I talked to you about. There may be sacrificing you do on that because you think if you were to ever try to do that, then you would start in another cycle of conflict. And there are plenty of places in the world where peace agreements were reached and amnesties were given. And I know Louise Mellinger was here recently, and she is kind of the guru on amnesties. And she will talk about this, right? You know, how much do you allow states and non-state actors to be forgiven and not held accountable in the interest of peace? So sometimes reaching that last point of peace agreements and the absence of conflict means that for the parties to the conflict, they give up their ability to actually hold perpetrators accountable. And we've seen this through truth commissions. There are ways in which there are systems to set up where the victim might get some sort of satisfaction by recognition of truth. The perpetrator speaks with him, but that perpetrator is never tried and convicted in a court of law. And so sometimes, as I said, moving towards peace means that there isn't justice, and they're not always aligned.
The last question that I think I'll ask you today, what's something that you wish we would have asked you?
I think, and I kind of touched upon it, is student activism, because last year was an extraordinary year that I've never seen before in all my years of teaching. And there are a variety of different kind of rights-based discourse that have come from what's happened, right? Freedom of expression, academic freedom. The Gaza war has, in my mind, framed it, but there's been a lot of content to it that I think is the hopeful part, because I think students are engaged in processes and arguments and law and human rights and humanitarian law in a way I've never seen before. And I think it gives me hope rather than fear about what's going to happen in the fall. And it's something that when you asked what gives me hope, it's that. And I think that the debates around freedom of expression and academic freedom will continue, but I think the most important thing to note is that in an academic space, in a university space, being able to raise questions and engage in discourse that's difficult is part of what we're here for. And my hope is that in a very safe environment, we'll be able to continue to do that throughout next year and for years to come. It may not be on one topic, but that this kind of igniting of this space to me was very exciting last year. Notwithstanding, I know the difficulties that it caused some, it was quite, it gave me hope.
Thank you for listening to this episode of Root of Conflict featuring Professor Kathleen Cavanaugh. This episode was produced and edited by Hannah Balikci and Nishita Karun. Special thanks to UC3P and the Pearson Institute for their continued support of this series. For more information on the Pearson Institute's research and events, visit their website at thepearsoninstitute.org and follow them on LinkedIn, Twitter, and Instagram at Pearson Inst. Inst is spelled I-N-S-T. Thank you. If you found this episode interesting, we invite you to join us for the 2024 Pearson Global Forum, Negotiations and Agreement. Join us on Friday, October 18th to hear from global experts as they discuss topics like the role of women in negotiations, speaking law to war, and other interesting panels around the theme of negotiations and agreement. This in-person and virtual event is free and open to all. You can find more information at thepearsonglobalforum.org.